And good afternoon, everybody, and welcome to the Young AFSA webinar on drafting arbitration agreements. Okay, while Vincent tries to join us, I will introduce everyone to our esteemed panel today, who I want to thank for taking time out of their busy schedules to join us. We've got some broad input from some people with some good experience in the arbitration world with us today. So I'd like to introduce them to you, starting with Leu Tameru. Leu, if you want to do a wave, you can for everyone. Leu is an international arbitration practitioner based in Ethiopia. She heads up the arbitration practice at TWAM Partners LLP, and she is listed in GAR's 45 under 45 global leaders of their generation for international arbitration. She is regularly involved in international arbitration cases concerning African private and state-owned entities, both as counsel and arbitrator. She also advises governments and international government organizations on investment and policy matters, such as serving as an expert in the drafting process on the African Continental Free Trade Area protocols. She's currently serving on the editorial boards of the ICC Bulletin and the Kluwer Journal of International Arbitration, and she previously taught law at Addis Ababa University. Thank you, Leu, for joining us. Next, I'd like to introduce you to Chandni Gopal. She's a dispute resolution partner at Weber Wensel in South Africa. She specializes in complex, high-stakes, multi-jurisdictional matters, which are monetarily, operationally, and reputationally significant. She has expertise in the full breadth of dispute resolution proceedings and dispute resolution avoidance techniques, with a particular focus on commercial and strategic domestic and international arbitration. She also works extensively in Africa, with her subject matter expertise extending to the energy, infrastructure, private equity, technology, and consumer sectors. Thank you, Chandni, for joining us today. Next up, we have Mavuto Sakala. He is the managing partner of the Zambia office in Bowmans. He specializes in corporate litigation, alternate dispute resolution, employment, and corporate investigations, and he has acted on some of Zambia's most complex and high-profile commercial litigation and arbitration matters. He is currently acting in 2 ICC arbitrations for mining companies involving a mining service contract and a copper refinery construction contract. Mavuto's experience extends to banking, mining, energy, and financial services, and he is also a member of the Chartered Institute of Arbitrators in both the London and Zambia chapters. Welcome, Mavuto. And then last but certainly not least, we have Jonathan Ripley-Evans, who is a partner at Herbert Smith Freehills in Johannesburg. He heads up the South African disputes practice there. He has extensive experience in alternative dispute resolution and general commercial litigation matters. His practice is geared towards ADR, and he specializes in the resolution of commercial disputes in a wide range of sectors, including energy, mining, tourism, hospitality, property, construction, and engineering. Jonathan also currently sits as a vice president of the AFSA International Court, and he was a core member of the drafting committee responsible for the revision of the AFSA International Commercial Arbitration Rules, which were launched in 2021. Jonathan as well for joining us. Vincent, I see you've managed to get online. I've managed to do the introductions of our panel to everyone. So if you don't mind taking us through what the purpose of the webinar will be, please, that would be excellent.
Thanks, Jonathan. Good afternoon, everybody. Look, I think we all know that ADR has increasingly been embraced as a far more efficient and collaborative approach to resolving disputes. Traditional litigation has sometimes been costly, adversarial, time-consuming, and lawyers and the like have then been advising their client to follow the ADR route. I mean, in the context of South Africa, we're all aware of the not-so-recent promulgation of the Rule 41 of the Uniform Rules of Court. There's also been a recent directive that mandated mandatory mediation in Gauteng. So we've seen that more and more parties then are referring their disputes to ADR. And we thought today we'll then have a session to discuss arbitration clauses. I mean, just to take it to the beginning, as we all know, arbitrations, the basis of any arbitration is consensus. So the arbitration agreement would then be fundamental in that discussion. And the purpose of this talk would then be, how does one avoid having your sort of pathological arbitration clauses? So the intention is to have quite an interactive discussion with the panel that we've assembled, and the discussion will mainly focus on what the requirements are for a valid arbitration clause, We'll provide a brief assessment of the AFSA model clauses. We'll also compare prevailing practices in South Africa, Zambia, Ethiopia, with a view of understanding some of the things around the seat of the arbitration, practical issues that arise around ad hoc institutional arbitrations, as well as looking at across arbitration agreements across a suite of agreements in large transactions. This webinar is designed for young practitioners, our members, students across Southern Africa, and broadly around the African continent. And the aim is to equip our attendees with essential knowledge and understanding on how you navigate through some of these elements that we're going to be discussing today. So as I said, we're going to be discussing the role and importance of arbitration agreements in commercial agreements. We'll offer some practical considerations and insights in how you go about drafting sound and enforceable arbitration agreements. And as I've mentioned, the issue of the seat, and then we'll compare the three jurisdictions being South Africa, Zambia, and Ethiopia. So feel free to drop some of the questions that you have in the chat box as and when you're going, and then we'll see how we introduce those questions. Jonathan, I don't know if there's anything you want to add or whether we should get straight into it.
Thanks, Vincent. Yeah, I think we can get straight into it. Just to note that we will monitor the chat box, and if a question is immediately relevant, we may pose it to the panel, but if not, we'll certainly try to deal with as many questions as we can at the end of the webinar, where we've set aside about 10 to 15 minutes for your questions.
Thanks, Jonathan. Maybe let's start with the first issue. How does one go about creating an arbitration agreement? Maybe I can address this question to Jonathan, and some of the members of the panel can also come in. What are sort of essential requirements in this jurisdiction on how you go about creating a valid arbitration agreement? And some of the issues that may arise there is how do you avoid a defective arbitration agreement? And should there be one? Should you be faced with a defective arbitration agreement? How do you go about dealing with issues of validity? Maybe you can give us into practical insights on how you deal with those issues. Thanks.
Just to clarify, Vincent, you're talking to this Jonathan, not the other Jonathan.
Yes, Rebs, thanks.
Hi, everyone. It really is a pleasure to be here. And thanks, guys, for setting this up. It really is a lovely opportunity to talk about a very, very important topic. We're going to have insights from the different jurisdictions just now, so some of the nuances, but at the core of arbitration, everyone knows, is this agreement. And I think the starting point is to appreciate that an arbitration agreement is an agreement first and foremost. If there's no agreement, you cannot arbitrate. And so the next question is, well, what do you require in order to make that agreement valid? Now, there are varying views on this. Some people believe that your essentialia of your arbitration clause would include things like your arbitral rules, your number of arbitrators, and the like. I take a different view. I think that as soon as the parties have agreed to arbitrate, full stop, you have an arbitration agreement. In almost any jurisdiction around the world, you will have an arbitration legislation. And quite often that piece of legislation supplements your arbitration clause. So the moment that the parties have reached an agreement to arbitrate, normally national law has a default position which deals with things like procedure, arbitral appointments, and the like. And there's always a default. So if the parties agree nothing more than to arbitrate, you go back to your legislation and say, well, what happens if the parties don't agree on something? And these days, there are very few jurisdictions around the world where those are not catered for. So if someone is challenging an arbitration clause, and we see it all the time, where people look for loopholes in an arbitration clause that's unenforceable because we didn't agree on a set of rules. As far as I'm concerned, it's absolute nonsense. You're either pro-arbitration or you're not. There's the default position. It's either 1 or 3 arbitrators. Normally, the arbitrator can determine his or her own procedure for the matter. There are default provisions relating to seats, which then triggers legislation related to challenges of arbitrators and the like. But at its core, an arbitration agreement is nothing more than an agreement to arbitrate. And just before I hand over to my panelists, in South Africa, just be aware that we've got the Domestic Act of 1965 and the International Act. We'll explore a little bit more of that in the discussion today, but it is important to understand that there are slightly different interpretations of an arbitration clause under those two acts. And the last point I just want to make on this one is in both the Domestic Act and the International Act, there is a requirement that the arbitration clause be in writing. That does not mean that an oral arbitration agreement is invalid. It simply means that if you orally agree to arbitrate an agreement, number one, you've got an evidentiary problem, which is why there is a requirement to have it in writing. And number two, the Act may not apply. And there's case law in South Africa that confirms this. Once you have an agreement to arbitrate in writing, then the legislation kicks in. If your arbitration agreement is not in writing, it is still an enforceable arbitration agreement, and an award is also enforceable. And I'll stop there, Vincent, and I'll hand over.
Thanks, Jonathan. Liu, maybe let's go to you. Would the experience in your jurisdiction be different? And then after that, we'll hand over to Mavuto.
Sure. I think it's a bit similar. So Ethiopia just came out with an act just a couple of years ago, right? In 2019, with the new Arbitration Act, which was actually quite a good portion of it is borrowed from the uncentral model law, which means that there's a lot of similarity between the International Act in South Africa concerning international arbitration and that of Ethiopia. The big debate, obviously, is whether an arbitration agreement has to be written or not, right? So it's quite clear that an arbitration agreement has to be written. But, and I kind of want to read the clause to you, if you just give me a minute, but an oral arbitration agreement is also valid in Ethiopia if you have two witnesses that have signed on a piece of paper saying they have seen you make an oral agreement to arbitrate. So that is the piece of evidence that you have to present in Ethiopia to be able to say, look, it's not written, but here it is, right? So I haven't yet seen that. I'm hoping I'll see that at some point in my career because it'll be a really fun, it would be a really fun case. But it pretty much is what's required. It's also the other portion is, you know, an arbitration agreement entered into electronically is also quite say it as valid under Ethiopian law, which is quite new because we did not have this. Our previous Arbitration Act was a part of the Civil Procedure Code, which is from 1960. So it was important to clearly outline that electronically entered into agreements are valid. The main requirement for that is that they be accessible when needed, so that you have a record of them somewhere, whether in a cloud or, you know, somewhere on someone's computer, but that it actually is accessible to all parties. That's kind of the aspect from Ethiopia.
Thanks, Lei. That's quite interesting. Mavuto, can you share your experience from a Zambian perspective?
Yes, thank you, Vincent, and good afternoon, everyone. I agree with the position Jonathan has advanced that as soon as it's clear from the agreement by the parties that they want their dispute to go to arbitration, I think that is sufficient. From a Zambian perspective, everything else will be filled in by the statute. You know, so if you don't agree the number of arbitrators, the statute, there's an arbitration act which will deal with that. If you didn't agree the rules that will be applicable to your arbitration, the Arbitration Act will deal with that. But I think what is important from a Zambian perspective is also to be aware of the subject matter of the arbitration. So not all matters are arbitrable. And so our Arbitration Act and other statutes have carved out some matters which may not go to arbitration. I have, for example, matrimonial causes, issues, you know, or child rights and marriage issues. Those are not arbitrable. So I think what is important as you are drafting an arbitration clause as a lawyer, you need to also be familiar with the subject matter of the agreement so that then you do not get into a situation where you draft an arbitration agreement and then it is in respect of a matter that is not, in terms of Zambian law, that is not arbitrable. I think that's all I can add on this, Vincent.
Thanks, Mavuto. Thanks. I'm going to hand over to Jonathan to ask the next question. Thank you.
Sure, thanks, Vincent. Before I do ask the next question, Chami, I just wanted to check, was there anything you wanted to add on the introductory topic, or?
Just perhaps to add, you asked what makes a defective arbitration agreement, and if you're in a world where an agreement is sufficient, then defective probably needs to go to the practical sense, right? If you've decided on a set of, say, essentialia, the scope, what kinds of disputes are arbitrable, it must just you must have regard to the position of the parties, what their intentions are, how many parties there are, what kind of rules you're looking at, their means, speed. So really how to avoid, defective from a practical sense is understand your transaction, understand your parties, understand how the rest of the agreement really works, and then understand how in a practical sense you would like the dispute to be solved. Yeah, so I think that's all I can add on this point, Jonathan.
Great, thank you very much. So yeah, so we've spoken about, what are the requirements for the agreement, and very often that's what we look at when parties are seeking to create their own arbitration agreement. But I think institutions seek to make this job a lot easier for parties by coming up with model clauses. And for example, we know that AFSA has a couple of model clauses that it uses and offers to parties to use for AFSA arbitrations. And I think I'm going to start with Jonathan Ripley-Evans again, because you have that close link to AFSA and you were involved in the production of the rules. But can you give us some insights onto what it is that institutions put into their model clauses and how they operate? I think you might be still on mute.
Sorry, John. Here we go. We just mentioned defective clauses, and the easiest way to create a defective clause is by talking too much. The more you put into a clause, the more chance you have of creating something that is unenforceable. And unfortunately, we've all seen this in practice, where we have these 3 or 4 page arbitration clauses or arbitration agreements, which are often contradictory, and that's where you start getting into trouble. So standard arbitration clauses are very underwhelming, and they're not really good for people who charge for or charge by the letter. They are incredibly short. The most effective arbitration clauses are incredibly short. And if you look at the clauses for any of the leading arbitral institutions, they are almost exactly the same. There's no fancy footwork involved, and that is deliberately so that the clause itself is clear and that everyone knows how to interpret it. And we tackled this when we drafted the new AFSA rules, and we wanted to draft a new international clause, because the existing clauses under the domestic rules we found could be slightly clumsy. And the international clause simply states, any dispute arising from or in connection with this contract shall be referred to and finally resolved by the Arbitration Foundation of Southern Africa in accordance with its international arbitration rules. Now, a few aspects there. Number one is you've got to identify a dispute. And then together with that dispute is the contractual relationship. So you can also expand it beyond the initial contractual relief that you want, but you have to specify that. So you normally talk about the relationship between the parties. We've spoken about an arbitration clause constituting a contract. So in the context of a contract, we have an agreement to refer disputes arising out of or relating to or connecting with this relationship or agreement. And then the big question is, what procedure are we going to follow? And we'll talk about it just now when we start talking about ad hoc versus institutional. But in AFSA's perspective, in AFSA's circumstances, we're talking about a reference to an arbitration administered by AFSA. Very importantly, if we want to specify the use of the international rules, we need to say so. In the international rules, there is a presumption in the preamble which says that insofar as the parties refer a matter to AFSA and they haven't specified that it is a purely domestic matter or they want the domestic rules to apply, the default is that it is to the international rules. We did that deliberately because the international rules are the updated version and it's aligned with international best practice. So when we drafted the AFSA clause, we didn't put in any fancy footwork. We modeled it on wording that is tried and tested around the world. you will see that the LCIA clause, the Hong Kong clause, the Singapore clause are very similar to the AFSA clause. And there is nothing in there that should come as a surprise to you. And I would encourage everyone to resist the temptation to add additional things into your clause. Other than that standard wording that we've spoken about, the only other things that you may want to deal with is number of arbitrators, usually 1 or 3, occasionally you see 5, but not very commonly, 1 or 3 arbitrators, the seat of the arbitration. Hopefully we'll get a moment to talk about that just now as well, and the importance of choosing the legal seat for your arbitration. Language of proceedings, if you wanted anything other than the language of the contract. And that's it. I think what I got there. That's all you need for an arbitration clause. Like I said, if you don't have any of those additional elements, it's not unenforceable. The acts provide for the acts fill in the gaps where you've left them, but that just then tailors how you want the matter to proceed. And again, John, if we have a little bit more time towards the end, I won't talk too much now. I do just want to talk a little bit about ad hoc arbitrations in accordance with the AFSA rules. It's a topic all on its own, but I would like us to debate and discuss that a little bit because I think it's very important, particularly for our current audience today, to understand the problems in doing something like that. Yeah.
Great, thank you. I think I'm going to open this question up to the rest of the panel for anything they want to add. I mean, all 3 of you have very busy practices of your own, and you advise clients on this on a regular basis. So is there anything in your experience that you would like to add about parties using institutional clauses and how they go about them, and maybe some experiences about, a party that was reluctant to do so, and then you convinced them one way or the other into using it? I see Mavuto came off of mute first, and then Leo, so maybe we'll go in that order.
Yes, I think what is important, the advantage obviously of using the institutional arbitration clause is that it is well drafted. I mean, Jonathan and team would have spent their time to put it together, so you probably don't need to worry about it being defective. But then you need to be clear, so you can't have it, I think Jonathan will speak about that at the end. You can't have it both ways. You can't be choosing an institutional arbitration clause, but then your process is ad hoc. You would need to be careful at doing that. So I think that's pretty much the advantage, that the institutional arbitration clause would be a well-tested, well-thought-out arbitration clause. And if you can, please don't amend it. And usually, I think this point I want to make, the arbitration clause becomes necessary when there's a dispute, and in most cases is when the contract has been terminated or has come to an end. So you need to be careful what sort of disputes you are including in your arbitration clause. I've come across one matter in Zambia where parties, for whatever reason, limited their arbitration clause to the life of the contract. But then the dispute was arising after the contract. And when they went to arbitration, the arbitrators, the arbitral panel said it had no jurisdiction because the contract had come to an end. So those are some of the issues that you need to be careful about.
Thanks, Mabuso. Leo?
Yeah, just to add on that, it's using the center's clauses, draft clauses, actually guarantees you one thing, which happens all the time. It's getting the name of the arbitration center correct. And you have so many arbitration clauses where the names are incorrect, and you now have to deal with the jurisdictional phase because you have one party that's trying to get out of it. And they're like, well, I had a contract that says the International Court of Arbitration, and the seat was in Geneva. And the argument was International Court of Arbitration is the ICC International Court of Arbitration. And they're like, no, but there is no such thing as an International Court of Arbitration. It didn't say the ICC International Court of Arbitration. So, and it was seated in Paris. So how do we know that this, and it was this entire jurisdictional phase that could have been avoided. And the arbitration could have actually moved forward. So you do put challenges in front of yourself by actually just avoid that by actually taking an arbitration center's draft clause. That's a good one. The other one is make sure it, and this is particularly contracts concerning, for example, FIDIC contracts, where you have a general part and a specific part, right? So it's to make sure that your arbitration clauses in both there are actually, the same. Because I just, again, recently came across an arbitration dispute where the parties gave us a document, and in the general contract, it says the parties agree to go to arbitration. And then in this special contract, it says they will go to court. And, obviously the special one is actually going to derogate over the general one, but they thought that by putting that in the general one, they were covered. And so that also is another issue that you could actually have. So that clarity on that is also really important. So I think these are the 2 points I'd put out.
All I have to add is probably to say never underestimate your counterparty's ability to pick apart language and grammar and syntax. If you have a very complex, unnecessarily wordy clause, a comma could make a difference, an and or could make a difference. And any party really looking to get out of having to arbitrate a dispute will try and pick it apart. So keep it simple. And yeah, the institutional rules are a good place to start. Of course, with the caveat that try not to mix ad hoc versus institutional. I think we'll get into that shortly.
Thanks, Shanmi. Yeah, and exactly. While the mic is with you, and on that note, I think we should move on to the discussion on the difference between the ad hoc and the institutional arbitrations. Could you maybe give us some opening comments on that? And then I know Jonathan Ripley-Evans said he had a few points to make. We can maybe move on to him after you.
So, sorry, I'm losing my voice here, but I would say, look, there's no one size fits all approach in arbitrations. Your institutional arbitrations, those are usually arbitrations where you have an institution like AFSA, the ICC, or the London Courts of International Arbitration, administering and really guiding your arbitration process from start to finish. There's a sort of like a check and balance usually in place. There are different divisions within an institution, a secretariat or a president who could make appointments. What is fantastic about institutional arbitration is that the entire kind of framework and support mechanism is there. And now if you use that with your model clause for that institution, as Leo correctly said, they speak to each other and there's a fair amount of seamlessness. An ad hoc arbitration is really one where the parties decide to administer their own arbitration in the main sense. That could be how they appoint your arbitrators, the length of the proceedings, what kind of interim measures they want to use. But really what can be quite problematic, and the panel has already alluded to this, is if you are going to create an ad hoc arbitration and apply rules which speak to institutional mechanisms, and that's where you can run into problems. And I think it would be helpful if the panel could give a couple of examples of those.
John, if I can maybe pick up from there, I mean, that's a perfect starting point for this discussion. It's become a bit of a pet peeve of mine, this topic. And strangely enough, when I joined HSF and started operating more globally in other jurisdictions, I realized how few ad hoc arbitrations actually exist in the pure commercial world across the globe. It was quite eye-opening to see the large portion of ad hoc arbitrations we administer in South Africa compared to many jurisdictions which I currently now am exposed to. And as a global firm, if we at any given time we've got 100 arbitrations running, maybe less than 5 of them are ad hoc. So it is a bit of an unusual thing globally, this concept of an ad hoc arbitration. And Johnny, you've touched on a few of the reasons why that is the case. It's more admin for the parties, but also there's structural reasons why you don't want to go ad hoc. In some jurisdictions around the world, only arbitral awards issued by a recognized institution are actually enforceable. So those are real practical reasons why you would want to do that. But the one thing that that I think is a very South African thing and is something that we need to get away from. And that is running an ad hoc arbitration in accordance with the AFSA rules. Now, the simple answer to that is not possible. You cannot run an AFSA ad hoc arbitration. It just doesn't work. And people make it work. And so you appoint an arbitrator and then you run in accordance with the procedural rules that you pick and choose as you go along. But the reality is that the AFSA rules are drafted in a way that makes them a body of rules, and that is what the parties have agreed to, if they've agreed to the AFSA rules. And one of the main reasons why people go ad hoc as opposed to institutional is always say AFSA is too expensive. Well, newsflash is AFSA is one of the cheapest institutions in the world for arbitrations, and there's a reason why people pay money. Maybe that's a topic for another webinar one other day. But if you start looking at the AFSA rules, you start out, and Article 1 deals with who AFSA is, talking about the body responsible for administering arbitration. You can't do that. You can't apply that clause in an ad hoc setting. Article 2 sets out the role of the court. The court is the decision-making body of AFSA. That doesn't apply in an ad hoc arbitration. Article 3, the request for the arbitration. Any party wishing to commence an arbitration under the rules shall deliver to the Secretariat. A Secretariat doesn't exist in an ad hoc arbitration. And there's an even bigger reason why. It's not just a practical reason why you've got problems. If you go to Article 34 of the model laws we have now in our International Arbitration Act, Article 34 is for the application for the setting aside of an arbitral award. And you read Article 34(2)(4). And this is where a party applies to have an arbitral award set aside by the court. That'll be a South African court for a South African seated arbitration. The party making the application furnishes proof that the composition of the tribunal or the arbitral procedure was not in accordance with the agreement of the parties. Now, if you refer to an arbitration under AFSA rules, the rules are incorporated into your agreement. The moment that you run an arbitration not in accordance with that agreement, the other party, the losing party, can run up to court and say, this arbitration wasn't conducted in accordance with the rules agreed between the parties. It's not something that we see often. I haven't seen a matter. It's coming. It's something that we haven't realized that is just fundamentally wrong from a pure principle basis. So all I would say is that if you refer to an AFSA arbitration, it is not an ad hoc arbitration. Don't turn it into one. If you are going to use ad hoc rules, rather use the UNCITRAL rules or some other ad hoc rules, but don't try and use the AFSA rules for an ad hoc arbitration. It may very well cause problems for you. I'm going to stop there, John, before I get too excited on the point.
Just to add on what you said, Jonathan, and you're very, very passionate about this, so I will. There's a few other, when you look at it from the council perspective, there's all of these issues, but then when you look at it from the arbitrator perspective, ad hoc arbitrations are actually really difficult to manage, right? So number one, how do you, not a lot of countries have what they call an escrow account mechanism. So how do you collect your arbitrators' fees? How do you make sure the arbitrators are paid? So that's a big job. I have a friend who's currently presiding in an ad hoc arbitration, and she's been chasing one of the parties to deliver a letter and what are the procedural orders, and they've just been so elusive, and so you have such additional stress on the arbitrators that you don't necessarily want to have on them, because they will be the ones making a decision in your case. So you really want to be the situation where you're actually making things a lot more facilitated and a lot easier. At the very end, as you mentioned, the enforceability aspect of an ad hoc arbitration is also a big issue, because there's instances where you would have a dissenting award, or just only two of the arbitrators are signing the award, which technically does make it an award, but then that leaves space for the challenge to say, well, we weren't served correctly. Whatever grounds, that 5 grounds or whatnot that you have on the, the New York Convention, or grounds upon which that the nationality, the seat of the award is made, to try and challenge, and trying to actually really explain that is going to take, it's an additional cost that you end up having to deal with again at the enforcement stage, then that you could have avoided again by having an institutional arbitration. Granted, yes, institutions do come at a cost, and parties are, especially these days, very, very watchful of how expensive it all becomes. But you can choose which center you want to do it. And we have a lot of virtual options in many centers. So I think that's also something to really consider in that instance.
Thanks, Lou. Yeah, so I think we're just passing the halfway mark now, and we can already see what all the important things are to consider to put into your arbitration agreement. And I think we're about to get to one of the most critical ones now. So I'm going to hand over to Vincent, and he'll walk us through that one, please.
Thanks, Jonathan. I think maybe let's move now to seed. Maybe I can pick this up with you. I mean, what does that mean? And why is it important? And what does it actually mean? I mean, is it a location? Is it domicile? Is it maybe the law of the contract? Like, what does it mean? And what happens if you choose the wrong seat? Maybe you can just give us some practical insights into that.
Yeah, thank you. So the seat really is the nationality of the award. So it's you're picking a citizenship, and it's which citizenship do you want your baby to have? Just given birth, you've got to figure out which passport is the best which passport gets me to as many countries as possible without having to deal with visas. And I think most of us deal with visas, so we understand the pain. And that really is what a seat is, right? So what we really mean by a seat is the moment you decide that this is going to be the seat of my arbitration, then it means you're going to be using the Arbitration Act of that country as the means through which the procedure of the arbitration will be taking place. So if Addis Ababa is your seat, you will then be using the Arbitration and Conciliation Act of Ethiopia as your procedure. So all of the procedures that are mentioned on there would be there. So if your arbitration agreement is made orally, you will then have to present 2 witnesses having written on a paper that they have seen this oral arbitration agreement being entered to, so that it actually becomes a valid arbitration agreement, and then we can move forward with the procedures. So that is why it's really important. So first would be it determines what valid clause of arbitration is. Secondly, it is very, very important because it depends on courts' attitude towards the arbitration process. So are courts going to be supporting your arbitration, or are courts going to be interfering with your arbitration? So the Ethiopian Arbitration Act, for example, is quite clear that in international arbitrations, the courts cannot interfere unless requested by the parties for interim measures, and in how they can actually intervene in according to that proclamation. So that's one important point. And because you've chosen Ethiopia as a seat, for example, Addis as a seat, you then now have to fit into what qualifies as an international arbitration or an domestic arbitration. And when you fit as a domestic arbitration, then you're dealing with the domestic arbitration rules, which are largely different than the international arbitration rules, because usually the international arbitration rules, let's say, are a lot more friendly for enforcement. And the domestic arbitration rules, unfortunately, and I really do not like that distinction, but that's a discussion for another day, are a lot harder in terms of enforcement. Usually there's some appeal or some form of appeal that's allowed in these arbitration awards, etc. So it becomes a lot more challenging. So you have to think about that. The other point that we raised earlier was the arbitrability point. And that is also another incredibly important point, because what can you take to arbitration and what can you not? So I'll just give you a small example. I have a client who has different agreements in different African countries, and they wanted to terminate that agreement in Ethiopia. And the arbitration is seated in Ethiopia. And so what they wanted to do was, okay, let's just dissolve this company. Let's start an arbitration to start the dissolution of this company. The reality is you can't have a dissolution and arbitration dissolution of a company in an arbitration proceeding in Ethiopia. It's an inarbitrable point. So that is an issue. You have to know what you can arbitrate or not. The other point to also consider is at the enforcement stage. And this is an important one because, again, this comes back to the visa issue. You want your award to go to as many countries as possible to be enforceable. So if you are seated in a country that's not a New York Convention signing or signatory country, you're then therefore banned from enforcing this award, or will have a lot more difficulty from enforcing this award in countries that have signed the New York Convention, but have taken the reciprocity reservation. So that means they will only enforce your award if it was made in a country that was a member of the New York Convention, signatory of the New York Convention. So you kind of limit yourself to that. But there are countries, though, who don't care about that, and that's France, for example. Any award really is enforceable in France, not because of the New York Convention, but because France civil law is actually very, very friendly in terms of enforcing awards. But in most countries, you will have that, that requirement. So these are the basics, and I think we all have war stories of how seats have been a bit difficult or made our lives a bit more difficult, but I think this is just the overall of seats.
Thanks. Yeah, that's quite interesting. Maybe let's get other insights from members of the panel. Any war stories? Maybe let's start with Chatni and then Mavuto and then
I have a horror story. Well, actually, it's tons of fun for the lawyers, but not quite for the client. It's a suite of transaction agreements. All of the agreements were interconditional. So essentially, if one of the jurisdictions kind of failed, two others could fall away. So it's kind of a cascading domino effect. That, of course, creates a situation where you could have 3, 4, 5, 6 disputes going on in different jurisdictions at the same time. Now, the arbitration agreement in those agreements, firstly, the governing law was the same for everybody. Okay, so we're applying South African law. But there were different seats in each little arbitration agreement. So we found ourselves in a world where it made sort of consolidation nearly impossible without agreement. We had different rules applying, different legislation applying. We had a client who needed to take South African law advice and then, what we would say local counsel advice on interpretation of the seat. Costs just skyrocketed. Emergency measures and interim relief were also very different in each of the jurisdictions. There were different requirements, for example, for security for costs. So look, it was tons of fun. The fees were probably great as well. The problem, however, is that you got an increasingly frustrated client. And I actually asked, surely this was kind of flagged at negotiation stage. And what they said was, look, it was, but there were so many other things that we were worried about and we thought were more important issues to be fighting about. We had a deadline in mind, and so we were like, this is not worth fighting about. And that has changed their perspective on disputes clauses kind of forever. This started about 3 years ago, and we're into the third arbitration. There's still at least 2 or 3 more to go.
Thanks, Chami. While you're still on that, there's a question in the chat box that I was hoping you could answer very briefly for us, and then Mavuto, there's a more meaty question for you. But Chami, the question for you is there a difference between the seat of arbitration and the venue where the arbitration takes place?
Yes, there is. So the seat of the arbitration, as Leu so eloquently put, it's your visa, it's your passport. You could have a passport for South Africa, but the venue of the arbitration is in Kampala, right? So that is the physical location of the arbitration. Of course, we live in a more kind of virtual world now, and perhaps venue has gotten less relevant in recent years, but it still is a very important distinction. Venue is the actual physical place, whereas your seat are the procedural laws that are going to apply to the arbitration, regardless of which country or city it's in.
Great, thank you. Mavuto, the question for you is, what are Mr. Sakala's views or thoughts on the inclusion of an arbitration clause in an employment contract in Zambia? Some argue that arbitration can be perceived to be biased towards employers in particular if an arbitration clause specifies an arbitrator.
Okay, no, thank you so much. So I think the starting point is to just confirm that in terms of Zambian law, an employment dispute can be arbitrable. So it is possible that you can have an arbitration clause in your employment contract. The difficulty is obviously that in as much as arbitration is quick, it requires parties to contribute towards the costs of the process, and the employer may have more capacity to pay because that's a private process, unlike a court process where the fees are not that expensive. And then from that perspective, a perception of bias can be created. So the individual who sits as a sole arbitrator, or indeed the panel that is sitting as an arbitral panel, knows that the party who is more likely to settle their fees is the employer. And then even in terms of bargaining power, the employer has a stronger position. But that's just a question of perception. In my opinion, you just need to ensure that you are not appointing an expensive institution, for example, such as ICC, for your employment arbitration a dispute. But I think it's possible that you can proceed with arbitration in employment. And from a legal perspective, I think there's nothing that stops it. That would be the answer, Jonathan.
Thanks, Mavuto. I think before we move on to the next question, maybe Reps, any horror stories, seat and venue?
Yeah, I've got two points that I'd like to make, and actually both involve Zambia. Just seems to be where I'm working quite a lot these days. The first one is, if you need any support of a court to protect your arbitration proceedings, you need to go to the courts at the seat of your arbitration. I had a particular matter. It's a South African seated arbitration between a European and a Zambian entity that chose South Africa as the seat. A bit of a disaster happening in Zambia. We have to run to the South African courts to get an anti-suit injunction. Thanks, Vedanta, another Zambian judgment that gave us a nice blueprint for that one. So you need to have a robust court that has a good understanding of the International Act. And what you can do. So very important, if you need protection from a court, it's the court of the seats. And the other one is another matter where I'm actually sitting as a member of a three-member tribunal. Again, Zambia, and the one party is from Israel, the other party is a Zambian entity, and the agreement was silent on the number of arbitrators. But the parties chose the Zambian Arbitration Act to govern the arbitration, but it was seated in South Africa. Now, under the Zambian Arbitration Act, which is also a model law country, the default is 3 arbitrators. So what do the parties do? They started the process. One party nominated an arbitrator. The other party didn't nominate an arbitrator. They went to a registered body. It was the Chartered Institute. Anyway, they constituted this tribunal that I'm currently on. And the arbitrators get together and we say, okay, that's great. South Africa is the seat, procedural law, South Africa, this and that. The only challenge is that the model law that is applicable in South Africa, the default is 1 arbitrator. And so now we've got the situation where the parties didn't agree on the number of arbitrators. We have the Zambian law, which was the election of the parties to govern the arbitration, but the procedural law of the arbitration says the default, if they haven't chosen, is 1 arbitrator. So that hasn't been resolved yet, but the easiest way to resolve it is at the first procedural hearing, the parties confirm the appointments of the arbitrators, and then that would validate their appointments. But that is an example of something where you have a conflict of law issue and the importance of choosing the right seat and understanding how the laws may differ at the seats compared to another chosen law. That's all. Thanks, Vince.
Thanks, Jonathan. Maybe let's now move on to arbitration agreements concluded with state-owned entities. I'm gonna throw this one to Mavuto. I mean, are there any specific requirements around validity and enforcement of those arbitration agreements? And how does one cater for privacy concerns, confidentiality concerns, and maybe give us sort of your practical insights on those type of arbitration agreements in Zambia?
No, thank you so much, Vincent. That's a very special issue to consider when you are dealing with state institutions. From a Zambian perspective, this would be at 3 levels. So you have the government itself, which will be the ministries and government departments. That's the first level. And then you have the state institutions that are created pursuant to statutes, so statutory bodies created pursuant to specific statutes. And then you have institutions that are incorporated as companies. And how you deal with all those 3 is a bit different. So with the state itself, which will be the ministries and the government departments, your contracting party would be either the Minister of Finance or the Attorney General. For the purposes of commercial disputes, the state will play or participate just like any other party would in the arbitration. The only issue would be on enforcement. So when you get your award, your options for enforcement in Zambia are then limited. If your intention is that after the award is obtained and you want to enforce it against the state, the normal enforcement mechanisms are not available. So basically, you just need to have the award registered and ask the government to pay. And there's nothing you can do. You cannot garnish, you cannot issue those enforcement writs against the state. And this is because the law, there is what we call the State Proceedings Act, prohibits parties from enforcing against the state. So that's one issue you need to consider when you are contracting with the state directly, because that may impact on how you enforce the state, enforce against the state. Obviously, the state doesn't want to be in default in perpetuity. So at some point you'll be paid, but then, in arbitration, you want process to be concluded quickly. And if you do not have means to enforce, then it becomes a problem. At the second level, it's with respect to statutory corporations. So these are bodies that are created pursuant to specific acts of parliament. There you need to see and check what sort of institution you're dealing with. So some of the institutions are protected in the same manner as the government is. The arbitration process is exactly the same as with a private party, but the issue is on enforcement. So if, for example, your arbitration is with the Zambia Railways, for example, which is a creation of a statute, the statute has provisions on how you can enforce and what you can enforce against. So there are some of the assets that are not available for you to enforce against. If it's against Bank of Zambia, for example, which is the central bank, again, there are limitations as to how you can enforce against such an institution. So you need to be careful in that respect. With respect to state corporations, which are companies, but they are state corporations just because the state has the majority shares in there. These are like any other private party. So you would be entitled to enforce. So on the question of enforcement, then you need to decide whether you then want this arbitration to be seated, outside Zambia, and consider whether Zambia has assets, if the state has assets outside Zambia that may be available for you to enforce. So that's the consideration you need to take into account. Issues of confidentiality, I think the process remains confidential, even if the other party is the state. The only question of confidentiality or lack of it comes in when you are registering the award for enforcement. So the awards, the enforcement process is through the court system, and our court system operates a public registry. So when you register the award for enforcement, then it becomes a public document. So if for any particular reasons you want to maintain confidentiality, then when you approach the court, you need to make a specific application to have the application, the matter, the file in which you're making the application sealed, and so that it's kept confidential. Not guaranteed, but at least you would have the order, and then you would have the basis of ensuring that the process is not made public. Vincent.
Mavuto, I mean, maybe let's hand over to Leo and Chutney. Maybe they can share their experiences on the same issue from a South African perspective as well as Ethiopia. Let me start with Leo. Thanks.
Sure. I think this is a really big pain point in Ethiopia, and I will tell you why. The first reason, I'm just going to read you Article 7 of the Ethiopian Proclamation on arbitration and conciliation, and it says, Article 7, non-arbitrable cases. The following shall not be submitted to arbitration. And on subarticle 7, it says, administrative contract, except where it is not permitted by law. So you can only imagine what administrative contract means. Technically, if you are getting into a contract with a state-owned entity, that could automatically be considered as an administrative contract. And that is a huge point of debate, especially for a lot of cases where state-owned entities have entered into, and that's kind of the shield that a lot of state-owned entities had used, saying, well, this is an administrative contract, it's not arbitrable, so let's go to court, and this is kind of the big, what I think the part of the Ethiopian Arbitration Act, and it really is a pain point. But what a lot of some of the clients that I've seen do is, as they sign a contract with an arbitration clause with a state-owned entity, they either request that there be clearance from the Ministry of Finance or the Attorney General Office. And getting that clearance or getting that letter from either government entities will then make it so that they won't have issues getting to an object. That will not come up as a jurisdictional point as this case emanates. So I think for me, this is really one of the biggest points.
Look, in South Africa, state-owned entities hardly ever actually agree to arbitration. That's not necessarily written down somewhere, but it's a policy decision, mostly because state-owned money raises sort of public purse considerations and a lot of kind of statutes actually that go around how public funds are used. At the end of the day, an arbitration of a state-owned entity would actually be funded in effect by the public purse, really. And so transparency and accountability issues arise. Now, that's not to say that it's not impossible. I myself have never been involved in a state-owned entity arbitration itself, but I've heard that, especially in where there's an element of investment. So think of IDC or Public Investment Corporation. There may well be instances where arbitrations are actually agreed to. Jonathan, do you have any insight on that?
I do still see them, particularly in construction-related initiatives by government entities. Arbitrations still are agreed to there. I think at the municipal level, there still are quite a lot of arbitrations taking place at that stage. The bigger challenges comes in on the investment protection side of things, and that's where we have the Protection of Investment Act, which again is a topic for another seminar. But from my perspective, when you're dealing with a state-owned entity, you're probably always going to encounter issues such as authority and limits of authority, and whether the party was authorized to enter into that agreement. It's a standard in every single one of the matters I've been involved in. There's a question about whether the party was authorized or not. And then normally there's a run-up to the court. Oh, there is no jurisdiction on the arbitrator. Then there's a debate as to who has the final call on that question. It's the textbook examples all the way through. So my view on engaging with state-owned entities and arbitral-related matters, you do have to be a bit more careful. You do have to, your checks and balances need to be in place. You need to tick the boxes, need to ensure that you've got the right people in the room and that they know what they're agreeing to. Because quite often one of the problems is that there's no continuity, so people disappear. And then all of a sudden, new people get involved. They know nothing of this. How on earth did these people do these things? And it becomes a bit of a mess at times. So just be careful. It's a little bit more straightforward generally in purely commercial matters.
Yeah. Just to add on what you said, Jonathan, it's I think we have to take this into consideration with regards to how the economy is structured in the majority of our countries. The state plays a really important role in the economy. whether as much as we're trying to privatize, as much as we're trying to inject private capital, move into a private, capital market and whatnot, the state still plays an incredibly important role. And it plays that role through its state-owned entities, through the statutory entities that are made to actually engage in commercial activities. So it is without a doubt that it's only a matter of time that every arbitration practitioner in the African continent at some point or another gets involved in a case where against or in favor of a state-owned entity. So I think this is an incredibly important question, and that's number one. Number two, having seen these state-owned entity cases, you come across a few things, and we've mentioned quite a few of them, but one that I feel like I see a lot is that lack of continuity. You see, contracts being terminated on basis that you don't understand, because again, that lack of continuity exists. So you have custodian of government that are being moved to a different, the minister has changed. You have a brand new minister, and there's a change of leadership in the state-owned entity, and suddenly certain contracts are out, and now we have new vendors and new contractors that are coming in to finish different projects. And that really is a huge pain point for many of our governments. I think people looking closer to state-owned entities and arbitration is actually an important one.
So maybe I can just add a point. I think one other thing to consider from a Zambian perspective, we also have some compulsory arbitration. So there are statutes that have provided that certain disputes have to go to arbitration. So you may not have a choice. I know we're dealing with drafting arbitration clauses, but certain disputes within the mining sector, so disputes between a surface rights holder versus the mine rights holder, has to go to arbitration. Disputes in forest concession has to go to arbitration. Some disputes under the investment arrangement under the Zambia Development Agency has to go to arbitration. So I think we need to consider beyond considering the clause, how you deal with these compulsory arbitration that are imposed by the statutes.
Ruta, if I can just quickly jump in, I think we're running out of time, but that's also another topic that the AFSA organizer may want to put that for another session that we have. I've also got some particular views on that. We have a few in South Africa as well. The one that stands out is 12B of the Petroleum Products Act, forced arbitration in relation to a dispute between a wholesaler and retailer in the petroleum industry. My view on that is that's not an arbitration. It's not enforceable under the New York Convention. It's enforceable under the local Domestic Arbitration Act. But for international purposes, I think that you would struggle to enforce that because at its very core, there is no arbitration agreement. And when parties are being forced to go to arbitration and there is no agreement on the arbitrator, on the rules, on the going to arbitration, it's actually not an arbitration. It's a quasi-judicial process. And I think that exists purely within the ambit of that statute. And I don't believe that it qualifies actually as an arbitration, but probably a debate for another day with my learned colleagues on the line.
Indeed. With that, I think we're at time. There were a couple of questions in the chat box, but Rips, thank you for answering those in writing. I think people have received their answers. So I'd just like to say a really big thank you to the panelists for taking the time to share their insights with us. I think it's been really useful and really helpful, and I hope that people have learned something and have taken away some useful insights. I do believe that a recording of this will be made available on the Young AFSA website for those who are interested. And yeah, we'll look forward to seeing people at our next webinar when it is set up. But for now, thank you, Chani, Rips, Mavuto, Leu, Vincent. It's been great. And thank you to everyone for attending and for listening so carefully.
Thanks, everyone. That was great. Thanks, guys.
Thank you. Bye-bye.